Welcome to a presentation on the Sale of Goods Act of 1930. In this presentation, let us give an introduction to the Sale of Goods Act. Till 1930, transactions relating to sale and purchase of goods were regulated by the Indian Contract Act because there was a contract between the two parties who are the buyers and the sellers. But then, in 1930, the Contract Act 1872 was cancelled and a separate act called as Indian Sale of Goods Act of 1930 was passed, and it came into being in 1st July 1930. With effect from 22nd September 1963, the word Indian was also being removed, and currently the act is called as the Sale of Goods Act of 1930. Now, what is the meaning of the contract of sale? Contract of sale is defined as a contract between the seller and the buyer. And what is this contract about? It is a contract wherein the seller transfers or agrees to transfer the property in goods to the buyer for a price. Now let us understand the terminologies. So the essentials of this particular contract is there are two parties. Okay, so it's a contract between two parties, namely the seller and the buyer. Who's a buyer? A person who buys or agrees to buy the goods. Seller is a person who sells or agrees to sell the goods. And what do we mean by the goods? The goods is a subject matter in the contract of sale. And what are goods? Here in Contract of Sale of Goods Act, only the movable properties are considered as goods. Immovable properties like land and building does not come under the Act, Sale of Goods Act. And when we are referring to property in goods, the term property refers to ownership. So here it means that when the seller transfers his property in goods to the buyer, he means that he's not only selling the possession of the goods, he's also selling or transferring the ownership of the goods to another person. So the word property refers to ownership. So the ownership that moves from one person to another person. So there is another term called as price. So the term price refers to the consideration in this contract. We know that every contract must have a lawful consideration, and the consideration in case of a sale is there must be a price. Without a price, it becomes a voluntary act or it becomes a gift. So it cannot be termed as a contract. Okay, so the price is a consideration in contract of sale. For instance, if goods are given against another goods, then it becomes a barter system and not the actual sale. So the sale can happen by transacting or by transferring cash or check, credit card or any negotiable instrument. The other important point to be noted in Contract of Sale of Goods Act is all the essential elements of a contract is also applicable for in contract of sale, because Contract of Sale Act is also a legal contract. So the essential elements like free consent of the parties, competencies of the parties, lawful consideration, lawful object, leading to a legal relationship, legal formalities, etc. is also applicable to these kind of contracts. Thank you for your patient listening.